This is Tim Manchin with the Manchin Injury Law Group. Going to talk to you today a little bit about a frequently asked question of us, and that is, do I have a medical negligence claim or a medical malpractice claim? These claims are some of the most difficult out there. It requires, first of all, that you prove that the physician or hospital that treated you did not do so with the same degree of skill and care as similarly trained physicians or hospitals. In other words, not the best care, but did you get the care that would have been provided by most physicians and most hospitals? And those are claims that, quite frankly, require experts to evaluate. Of course, experts cost money, and the law firm has to look and think about it and try to make a decision on whether it's a case that should go to an expert. A lot of times we'll have people that maybe we can call that don't cost us a lot of money just to give us an initial feeling. We have our own personnel on staff who do medical research and will tell us what the textbooks and other treatises say is the right way to treat a particular condition. That'll help us as well. But it's not enough to prove just that there was negligence, in other words, that they fell below that standard of care. You also have to prove that it caused substantial harm, or that it was the substantial factor in bringing about the harm. So I guess the best way for you to understand that is if you have cancer and some medical provider failed to diagnose it in a timely fashion, they failed to conduct the appropriate tests at the right time given the conditions and symptoms that you were reporting, you have to be able to show that it made a difference in the outcome. So if somebody has a particularly aggressive form of cancer that never gets cured anyway, then even though there may be negligence, there's no claim because you can't prove the damages in the case because it was going to happen anyway. On the other hand, there are many types of cancer and other conditions which, if you catch them at an early stage, can be very, very treatable and may have a survival rate of up to 90% if it's caught at the right stage. And in those situations, you can prove that it was a substantial factor in bringing about that ultimate harm to you as a patient. All these cases are very expensive. There are caps on the amount of damages that you can recover in these cases under West Virginia law, unfortunately. One of those caps is that in most cases you're only going to be able to collect pain and suffering in a total amount of up to $250,000. If there's loss of a bodily system or death, then that limit goes up to $500,000. In addition to those numbers, though, you can collect whatever your economic losses are in terms of your lost wages and other things that you maybe had to spend out of pocket or lost in terms of out-of-pocket expenses. There's another, though, serious cap, and that is a trauma cap, and that means that if you went in through the emergency room at a qualified trauma unit and you were treated for a particular condition and something bad happened to you, then your cap is only $500,000, no matter what your economic expenses were, no matter how much your medical bills are, no matter if you're going to be paralyzed for life. So these are important things that we have to wade through and try to evaluate to figure out whether you have a viable medical negligence claim.